In 1817, a man named Abraham Thornton stood in a British courtroom and did something that stunned everyone present. When accused of murder, he threw down a glove and demanded trial by combat. And here's the shocking part. It was technically still legal. The court had no choice but to acknowledge that trial by combat, a medieval legal procedure that most people assumed had disappeared centuries earlier, was never actually abolished in English law. This one moment exposed a gap in the legal system that had existed for over 400 years. Welcome to Ash and Crown History, where we dive deep into the legal procedures, royal decrees, and historical systems that shaped our world. Today, we're examining trial by combat, not as a romantic medieval myth, but as an actual legal procedure with specific rules, documented cases, and real consequences. We're going to examine the judicial mechanics, the statutes that govern these duels, and the champions who fought them. Because understanding how trial by combat actually worked reveals something fascinating about how legal systems evolve and how procedural rules shape justice itself. And if you're new here, hit that subscribe button now, because we're going deep into historical legal systems that are way more complex and fascinating than any courtroom drama on TV. Let's start with the fundamentals. Trial by combat was a formal legal procedure used throughout medieval Europe to resolve disputes and determine guilt or innocence. But it wasn't just two people fighting in a field. It was a highly regulated judicial process governed by specific statutes, overseen by judges, and bound by procedural rules as complex as any modern trial. The legal foundation for trial by combat in England was established in 1166 with the Assize of Clarendon under Henry II. This statute formally recognized trial by combat as one of several methods of proof available in English courts. The procedure was later codified in more detail through various regional statutes and manuals. Here's how the basic legal framework operated. When a dispute arose that couldn't be resolved through other means, one party could challenge the other to trial by combat. This challenge had to be made formally in court before a judge. The challenge itself was called throwing down the gauntlet, literally throwing a glove or piece of armor on the ground as a formal legal declaration. Once the challenge was issued, the opposing party had three options. First, they could accept the challenge and agree to combat. Second, they could refuse, which in many jurisdictions was considered an admission of guilt or an abandonment of their claim. Third, in some cases, they could request an alternative form of trial, though this option wasn't always available depending on the type of case and the jurisdiction. If both parties agreed to trial by combat, the court would then set the terms. And this is where the judicial mechanics become fascinating. The court had to determine several critical procedural questions, all governed by specific statutes and local customs. Let's look at a diagram of the typical trial by combat procedure. First, the court would establish the date and location of the combat. This wasn't arbitrary. Statutes specified that the combat had to take place within a certain time frame, usually between 40 and 60 days from the challenge, to give both parties time to prepare. The location had to be a designated field, usually attached to the court or castle where the case was being heard. Second, the court would determine the weapons to be used. This varied significantly by region and by the type of case. For criminal accusations, particularly appeals of felony, the weapons were typically wooden staves and leather shields. For civil disputes over land, combatants might use swords. The Statute of Westminster from 1275 specifically outlined weapon requirements for different types of cases. Third, the court had to establish the rules of engagement. Here's where it gets really detailed. Statutes specified the exact dimensions of the combat area, typically a square field measuring 60 feet on each side. The ground had to be level and cleared of obstacles. The combat would begin at sunrise and could continue until the stars appeared, giving both parties maximum daylight to prove their case. Fourth, the court would appoint officials to oversee the combat. This included a marshal to enforce the rules, clerks to record the proceedings, and often a priest to hear confessions and provide last rites if necessary. The judge presiding over the case would observe but not interfere unless the rules were violated. Now, let's talk about the champions, because this is where trial by combat becomes a unique legal institution. In many cases, the actual parties to the dispute didn't fight themselves. Instead, they hired champions, professional fighters who would represent them in combat. The rules governing champions were complex and varied by jurisdiction. In England, the use of champions was heavily regulated by statute. For criminal cases, the accused generally had to fight personally. They couldn't hire a champion. This rule was based on the legal theory that guilt or innocence was a divine judgment on the specific individual, not on whoever could hire the best fighter. However, for civil cases, particularly disputes over land ownership, both parties could employ champions. This created a fascinating legal market. Professional champions advertised their services, negotiated fees, and built reputations based on their success rates. They were, in essence, the trial lawyers of their era. The legal relationship between a party and their champion was governed by specific rules. The champion had to swear an oath that they believed in the justice of their client's cause. This oath was taken before the court and was considered binding. If a champion was later found to have fought for a cause they knew to be unjust, they could face legal penalties. Let me give you a specific historical example with full details. In 1220, a land dispute case in England pitted John of Ashford against William of Canterbury. Both men claimed ownership of a manor in Kent. After lengthy court proceedings failed to resolve the dispute, John challenged William to trial by combat. Both men chose to employ champions. John hired a professional fighter named Robert the Red, so called because of his red hair and ruddy complexion. William employed a champion named Geoffrey of York. The court records, which still exist, document the entire proceeding. The combat was scheduled for June 15, 1220, at the field adjacent to Canterbury Castle. The court specified that both champions would fight with wooden staves, approximately 5 feet in length, and small round shields made of leather stretched over wood. No metal weapons were permitted. On the appointed day, both champions appeared before the judge. They each swore the required oaths, that they believed in the justice of their client's cause, that they carried no charms or magical items, and that they would fight fairly according to the established rules. The combat area was marked out as a square, 60 feet on each side. The ground was inspected and cleared. At sunrise, the marshal gave the signal and the combat began. According to the court records, the fight lasted approximately 2 hours. Robert the Red struck Geoffrey repeatedly, and eventually Geoffrey fell to the ground. Under the rules, Geoffrey had 3 options at this point. He could rise and continue fighting, he could yield and admit defeat, or he could remain down until sunset, at which point the combat would be ruled a draw. Geoffrey chose to yield. The moment he spoke the word of surrender, the marshal stopped the combat. The judge then rendered the legal consequence. William of Canterbury had lost the trial by combat, and therefore lost his claim to the manor. The land was awarded to John of Ashford. This case illustrates several important aspects of trial by combat mechanics. First, the outcome wasn't death, it was submission or incapacitation. The goal wasn't to kill your opponent, but to force them to yield or to prove yourself the superior fighter. Second, the entire proceeding was carefully documented by court clerks, just like any other legal procedure. Third, the combat itself was governed by specific rules that the marshal enforced throughout the fight. Now let's examine the different types of trial by combat, because the rules varied significantly depending on the type of case. There were essentially three categories of cases where trial by combat could be used. First, appeals of felony. This was when someone was accused of a serious crime like murder, rape, or robbery. In these cases, the accuser had to be the victim or, in murder cases, a close relative of the victim. The accuser would make a formal appeal in court, and if the accused denied the charges, the accuser could demand trial by combat. For appeals of felony, the rules were particularly strict. Both the accuser and the accused had to fight personally, no champions were allowed. The weapons were standardized, wooden staves and leather shields. The combat continued until one party was killed, yielded, or until the stars appeared at night. If the accused won the combat, they were declared innocent and released. If the accuser won, the accused was immediately executed, usually by hanging. This immediate execution was a key feature. The combat itself was the trial, and the verdict was carried out on the spot. Second, civil disputes, particularly over land ownership. These cases allowed for champions and had somewhat different rules. The weapons could vary depending on local custom, but swords were common. The combat didn't have to continue until death, yielding, or incapacitation was sufficient. The legal consequence of losing a civil trial by combat was the loss of the disputed property. The winner's claim was established as legal fact, and the loser had no right of appeal. This finality was one of the key features that made trial by combat attractive to some litigants. It resolved disputes permanently. Third, challenges to judicial decisions. In some jurisdictions, if a party believed a judge had rendered an unjust decision, they could challenge the judge to combat. This was rare and heavily restricted by statute, but it did exist as a legal option in certain circumstances. Before we continue, if you're finding this deep dive into medieval legal mechanics as fascinating as I do, make sure you're subscribed to Ash and Crown History. We cover royal courts, legal systems, and historical procedures with this level of detail every week. Hit that subscribe button so you don't miss our next exploration into historical law. Let's look at a diagram showing the typical layout of a trial by combat field. The square combat area would be marked with ropes or wooden barriers. At each corner, there would be a post. The two combatants would enter from opposite sides. The judge would observe from an elevated position outside the combat area. The marshal would stand at the edge of the square, ready to intervene if rules were violated. Around the perimeter, there would be space for witnesses and observers. Unlike modern trials which might limit attendance, trial by combat was often a public spectacle. The theory was that public observation ensured fairness and prevented corruption. Now, let's talk about the specific rules of engagement during the combat itself, because this is where the judicial mechanics become most detailed. These rules were codified in various statutes and manuals, and they varied by region, but certain principles were widespread. First, the rule of arms. Combatants were required to use only the approved weapons. Any attempt to use additional weapons or to bring prohibited items into the combat area was grounds for immediate disqualification. The marshal would inspect both combatants before the fight to ensure compliance. Second, the rule of the square. Combatants had to remain within the marked combat area. If either fighter deliberately left the square, they could be declared to have fled, which meant they lost the case. However, if they were forced out by their opponent's actions, they could re-enter. Third, the rule of daylight. Combat had to take place during daylight hours. It would begin at sunrise and could continue until the stars became visible. If neither combatant had won by nightfall, the result depended on the type of case. In some jurisdictions, a draw meant the accused was acquitted. In others, a draw meant the case would be decided by other means. Fourth, the rule of intervention. The marshal could stop the combat if either fighter violated the rules or if there was clear evidence of foul play. However, the marshal could not stop the combat simply because one fighter was losing. The combat had to run its course. Fifth, the rule of submission. A combatant could yield at any time by speaking a word of surrender or by making a specific gesture, such as raising their hand. The moment surrender was indicated, the marshal was required to stop the combat immediately. Continuing to fight after surrender was a serious offense that could result in criminal charges. Let me give you another specific case that illustrates these rules in action. In 1386, a case in France involved two knights, Jean de Carrouges and Jacques Gris. Gris was accused of assaulting Carrouges' wife. After the regular courts failed to resolve the case, Carrouges challenged Gris to trial by combat. This case is one of the best documented trials by combat in history. The King of France, Charles VI, personally oversaw the proceedings. The combat took place at the monastery of Saint Martin de Champs in Paris on December 29, 1386. The rules for this combat were established by royal decree. Both knights would fight on horseback, armed with lances, swords, and daggers. They would wear full armor. The combat area was a large rectangular field, and the combat would continue until one combatant was killed or yielded. The combat began with a joust. Both knights charged at each other with lances. De Carrouges' lance struck Gris, knocking him from his horse. Both knights then continued the fight on foot with swords. After an extended sword fight, de Carrouges managed to knock Gris to the ground. He then drew his dagger and demanded Gris surrender. Gris refused to yield. De Carrouges then delivered a fatal strike. Gris died on the field. According to the established rules, this meant de Carrouges had won the trial by combat, and Gris was declared guilty of the accused crime. The body of Gris was subjected to the legal punishment for his crime. Under French law at the time, the corpse of someone found guilty through trial by combat could be subjected to public humiliation and execution rituals, even though the person was already dead. This legal principle reinforced that the combat's outcome was a judicial verdict, not just a fight. This case demonstrates several important aspects of trial by combat mechanics. First, the involvement of high authority. The king personally sanctioned and oversaw the combat, which gave it legal weight. Second, the specific rules were established in advance by decree, not left to chance. Third, The outcome of the combat had immediate and irreversible legal consequences. Now, let's examine how different regions had different rules for trial by combat. This variation is important because it shows how trial by combat wasn't a single unified system but rather a family of related legal procedures. In England, trial by combat was governed primarily by common law and specific statutes. The Assize of Clarendon in 1166 and the Statute of Westminster in 1275 established the framework. English trial by combat tended to be more restrictive. Champions were limited in criminal cases, and the types of cases eligible for trial by combat were carefully defined. In France, trial by combat was governed by a mix of royal decrees and regional customs. French practice tended to allow more elaborate armor and weapons, particularly for noble combatants. The French also had a more developed system of professional champions, with guilds and formal training programs. In the Holy Roman Empire, trial by combat varied significantly by principality. Some regions allowed it broadly, while others restricted it severely. The German legal tradition developed the concept of judicial dueling grounds, specific locations designated and maintained for trial by combat, complete with permanent facilities for judges and observers. In Italy, particularly in the northern city-states, trial by combat was integrated with the emerging legal profession. Italian practice developed sophisticated rules for when trial by combat could be demanded versus when other forms of proof were required. The Italian legal scholar Bartolus de Saxoferrato wrote extensively about the procedures for trial by combat in his 14th-century legal treatises. Let's look at a specific statute to see how detailed these rules could be. The Constitutions of Melfi, promulgated by Emperor Frederick II in 1231, included specific provisions about trial by combat. Article 31 stated that trial by combat could only be used when there was no other form of proof available. Article 32 specified that combatants had to swear oaths before combat, and that false oaths would result in penalties even if the swearer won the combat. Article 33 outlined the size and preparation of the combat field. It had to be level ground, cleared of stones and obstacles, measuring at least 60 feet square for foot combat or 120 feet square for mounted combat. Article 34 specified that the judge must appoint a marshal who was responsible for ensuring fair conduct, and that this marshal had the authority to stop the combat if rules were violated. These detailed statutory provisions show that trial by combat was treated as a serious legal procedure, not a barbaric free-for-all. The law prescribed specific requirements, and courts were expected to follow them. Now let's discuss the role of evidence and procedure before the combat even began. Trial by combat wasn't the first resort. It was typically used when other methods of proof had failed or weren't available. In most jurisdictions, before trial by combat could be granted, there had to be a preliminary hearing. During this hearing, the judge would examine whether trial by combat was appropriate for this type of case. Not all cases were eligible. Generally, serious criminal accusations or significant property disputes were eligible, but minor civil matters were not. The judge would also examine whether other forms of proof were available. If there were reliable witnesses, documents, or other evidence, the judge might require that evidence to be presented first. Trial by combat was often a last resort when the evidence was evenly balanced or when credible evidence was unavailable. If the judge determined that trial by combat was appropriate, both parties would be required to post bond. This was a financial guarantee that they would appear on the appointed day and fight according to the rules. If a party failed to appear, they forfeited the bond and lost the case by default. The parties would also need to submit their choice of weapons and armor to the court for approval. The judge would ensure that the weapons met the statutory requirements and that both parties had equivalent equipment. If one party had an unfair advantage in equipment, the judge could require modifications. Let me give you another specific example. In 1287, a property dispute in Yorkshire, England involved two landowners, Thomas de Moulton and Henry de Percy. After preliminary hearings failed to resolve their competing claims to a tract of forest land, the court authorized trial by combat. The court records show the detailed procedure. First, both parties posted bond of 100 marks each, a substantial sum. Second, they each submitted their proposed weapons, single-handed swords and small round shields. The judge approved these weapons as appropriate for a civil land dispute. Third, the judge appointed officials, Sir Robert de Ros as marshal, Brother William of Fountains Abbey as chaplain, and two clerks to record the proceedings. Fourth, the court set the date, 40 days from the authorization, which was the minimum statutory period. On the appointed day, both parties presented their champions. De Moulton employed a champion named John of Holderness, while de Percy employed William of Scarborough. Both champions swore the required oaths. The combat began at sunrise. According to the records, the fight lasted until midday. William of Scarborough sustained an injury to his leg and could no longer stand. He yielded, and the marshal immediately stopped the combat. The judge then ruled that de Moulton had proven his claim to the forest land. What's interesting about this case is what happened next. The court record shows that de Percy attempted to appeal the decision, arguing that his champion had been injured by accident, not by superior skill. The judge rejected this appeal, citing established precedent that the outcome of trial by combat was final and not subject to appeal except in cases of proven fraud or rule violations. This brings us to an important point about trial by combat: the finality of the verdict. In most jurisdictions, the outcome of a trial by combat was considered a definitive legal judgment. The theory was that God or fate had determined the outcome, and therefore human courts couldn't overturn it. However, there were limited exceptions. If it could be proven that one party had cheated, for example, by bribing the marshal or by using prohibited weapons or charms, then the result could be overturned. But the burden of proof for such claims was extremely high. Let's talk about what happened when someone won a trial by combat. The legal consequences varied by type of case, but they were always immediate and severe. In criminal cases, if the accused was defeated, they were executed immediately, usually by hanging. The execution would take place at the combat field or immediately adjacent to it. There was no delay, no opportunity for pardon or clemency. The combat itself was the trial, and the verdict was carried out instantly. If the accused won the combat, they were declared innocent and released immediately. All charges were dropped, and they could not be tried again for the same offense. This was similar to modern double jeopardy rules. In civil cases, if the challenger won, the disputed property or right was immediately awarded to them. Legal documents transferring ownership would be prepared on the spot. If the challenger lost, their claim was permanently dismissed, and they could not bring it again. For the champions, there were also legal consequences. A champion who won would receive their agreed-upon payment from their client. Champions who had successful records could command higher fees for future cases. A champion who lost wasn't personally penalized unless they were found to have violated the rules. However, if a champion was found to have fought knowing their client's cause was unjust, they could face serious penalties. Some statutes prescribed that such champions could have their hand cut off or be branded as perjurers. This was to discourage champions from fighting purely for money without regard to justice. If you're still watching, you're clearly someone who appreciates the intricate details of historical legal systems. That's exactly what we do here at Ash and Crown History. We go beyond the surface-level stories to examine how these systems actually worked. Subscribe to the channel and click the notification bell so you never miss these deep dives into legal and royal history. Now let's examine the decline of trial by combat, because understanding how it ended reveals important things about legal evolution. Trial by combat didn't disappear overnight. It gradually fell out of use over several centuries. The first major blow came from the Church. The Fourth Lateran Council in 1215 prohibited clergy from participating in trials by ordeal, which included trial by combat. Since clergy were needed to administer the oaths and provide religious sanction for the proceedings, this made trial by combat more difficult to conduct. However, the prohibition wasn't absolute. Secular courts continued to offer trial by combat as an option, just without clerical involvement. What really drove the decline was the development of alternative legal procedures. The rise of jury trials in England during the 13th century provided an alternative method of determining facts. Juries could hear evidence and render verdicts without requiring physical combat. This was faster, cheaper, and less risky for the parties involved. By the 14th century, trial by combat was becoming rare in civil cases. Parties increasingly chose jury trials instead. However, trial by combat remained technically available for certain types of criminal accusations. In 1487, a statute was passed in England that began to restrict trial by combat more formally. The statute didn't abolish it entirely, but it limited the types of cases where it could be used and made it easier for accused persons to choose jury trial instead. In France, trial by combat persisted longer among the nobility, who viewed it as a matter of honor. However, royal decrees in the 16th century began to restrict it, requiring royal permission for any trial by combat. By the 17th century, such permission was rarely granted. The Holy Roman Empire saw a similar gradual decline. The Carolina Code of 1532 established more formal criminal procedures that made trial by combat unnecessary for most cases. While the code didn't formally abolish trial by combat, it made alternative procedures the default. But here's the fascinating part. Trial by combat was never formally abolished in England. It simply fell into disuse. Parliament assumed it was gone, so they never passed a statute specifically abolishing it. This oversight led to the shocking case I mentioned at the beginning. In 1817, Abraham Thornton was accused of murdering Mary Ashford. The evidence was circumstantial, and a jury found him not guilty. However, Mary's brother William Ashford then brought an appeal of murder, an ancient procedure that allowed the victim's family to prosecute even after a jury acquittal. Thornton's lawyers discovered that for appeals of murder, the accused had the legal right to demand trial by combat. Thornton appeared in court and threw down his gauntlet, formally challenging William Ashford to combat. The court was stunned. Judges researched the law and found that Thornton was technically correct. Trial by combat had never been abolished for appeals of murder. William Ashford, who was not a fighter, refused the combat. Under the ancient rules, this meant he abandoned his appeal, and Thornton was released. This case caused a public scandal. How could such an archaic procedure still be legal? Parliament was forced to act. In 1819, they passed the Appeals of Murder Act, which formally abolished both appeals of murder and trial by combat. This is one of those strange moments in legal history where an ancient procedure survived in the law books long after everyone thought it was dead. The Thornton case forced Parliament to clean up the statute books and formally close this medieval loophole. So what's the legacy of trial by combat? How does this medieval procedure connect to modern law? There are actually several important connections. First, the concept of champions evolved into modern legal representation. Just as medieval litigants hired champions to fight for them, modern litigants hire attorneys to argue for them. The champion's oath to believe in the justice of their client's cause has parallels in modern rules of professional ethics for lawyers. Second, the emphasis on procedural rules in trial by combat influenced the development of formal procedural law. The detailed statutes governing how combat should be conducted, what weapons were allowed, and how officials should supervise the process. All of this contributed to the idea that legal procedures should be carefully specified and followed. Third, the finality of trial by combat verdicts relates to modern concepts of residential judicata, the principle that once a case is decided, it can't be relitigated. While we have more exceptions today, the basic idea that legal judgments should be final has roots in practices like trial by combat. Fourth, the gradual replacement of trial by combat with jury trials shows how legal systems evolve. When better procedures become available, older ones fade away. This pattern continues today as legal systems adopt new technologies and methods. Let's look at one more diagram to illustrate the complete process of trial by combat from beginning to end. It started with a legal dispute and a formal challenge in court. Then came the preliminary hearing where the judge determined if trial by combat was appropriate. Next, the parties posted bond and submitted their weapons for approval. The court appointed officials and set the date. Both parties or their champions swore oaths. The combat was conducted according to the established rules. Finally, the verdict was rendered based on the outcome, and legal consequences were implemented immediately. This entire process, from challenge to final judgment, could take anywhere from 40 days to several months, depending on the jurisdiction and the complexity of the case. But once the combat was fought, the resolution was immediate and final. Looking at trial by combat as a legal procedure rather than a romantic medieval custom reveals something important about how law works. Legal systems are designed to resolve disputes definitively. Trial by combat was one method, albeit a violent and risky one. It had clear procedures, established rules, and final outcomes. Modern legal systems have better methods, but they serve the same fundamental purpose: to resolve disputes according to established procedures that all parties accept as legitimate. The evolution from trial by combat to modern trials shows human societies gradually developing better ways to achieve justice. The detailed statutes and procedural rules that govern trial by combat show that even in the medieval period, there was an understanding that legal procedures needed to be fair, predictable, and binding. The law couldn't be arbitrary or subject to the whims of individual judges. It had to follow established rules. This principle, that law should be governed by rules rather than arbitrary power, is one of the foundations of modern legal systems. Trial by combat, for all its violence and strangeness to modern eyes, embodied this principle. The rules were written down, published, and enforced. Parties knew in advance what procedures would be followed. Officials had defined roles and responsibilities. So when we look at trial by combat, we're not just looking at a curious historical oddity. We're looking at an early form of procedural law, complete with statutes, judicial oversight, and enforceable rules. It's a window into how legal systems develop and evolve over time. The next time you see trial by combat portrayed in a movie or TV show, remember that the reality was much more complex than a simple fight. It was a formal legal procedure, governed by detailed statutes, overseen by judges, and bound by rules that both parties had to follow. It was law in action, medieval style. Understanding trial by combat helps us appreciate how far legal systems have come, but also helps us recognize the continuities. The search for fair procedures, the need for finality in legal judgments, the importance of rules over arbitrary power, these principles connected medieval trial by combat to modern legal systems. If you found this deep dive into the legal mechanics of trial by combat fascinating, leave a comment below. What surprised you most? Did you know about the detailed procedural rules? Had you heard about the Thornton case in 1817? Let's discuss it in the comments. And here's the important part. If you want more detailed explorations of legal history and how historical legal procedures connect to modern law, you need to subscribe to Ash and Crown History right now. We're going to keep examining the evolution of legal systems, the development of procedural rules, and the fascinating cases that shaped legal history. Click that subscribe button and turn on notifications so you don't miss a single episode. Because understanding where law came from helps us understand where it's going. Trial by combat may be long gone, but the principles it embodied, fair procedures, established rules, and final resolution of disputes, those principles are still with us today. Here at Ash and Crown History, we believe that history isn't just about dates and battles. It's about understanding the systems, the laws, and the institutions that shape society. And when you understand these historical systems, you understand the modern world better. So subscribe to Ash and Crown History, hit that notification bell, and join us as we continue to explore the fascinating intersection of law, history, and royal power. We've got episodes coming up on medieval court procedures, the development of common law, royal justice systems, and much more. Thanks for watching this deep dive into trial by combat. Remember, even the strangest historical legal procedures have something to teach us about justice, fairness, and the rule of law. I'll see you in the next episode of Ash and Crown History, where we'll continue exploring the legal systems and royal institutions that shaped our world. Until then, keep learning, keep questioning, and keep exploring history. Subscribe to Ash and Crown History now, and let's keep uncovering the fascinating details of legal and royal history together.